All right, it's Roland Jones. Thanks for watching. This is another video that we're doing on a bankruptcy issue. This is about, and of course, the slideshow is not legal advice on your particular case, for the good reason that I don't know the facts of your particular case. This is just general information. It's not legal advice. Okay, this video is about reclamation, which is an extremely important topic that a lot of people misunderstand or don't know anything about in the context of a bankruptcy filing. The law that we're going to focus on is a bankruptcy statute that deals with reclamation in the context of a bankruptcy filing. However, what it really is an extension or a conversion of rights that already existed under state law. Under state law, under section 2702 of the Uniform Commercial Code, a seller is given the right of reclamation. And when there's a bankruptcy filing, section 546 of the Bankruptcy Code essentially replaces state law and provides similar rights but different rights. And you need to be aware of what those different rights are. So what's reclamation? Let me just talk about that for a second. It's a very simple concept. You're selling product to a customer, and then you find out customer's broke, customer's insolvent, customer goes out of business shortly thereafter. In the case of a bankruptcy filing, they file bankruptcy shortly thereafter. So it's not very fair if you're selling product and all of a sudden you're finding out that your customer is accepting your product, hasn't paid for it yet, and just went bankrupt. So the concept is, hey, of course they knew they were going to go bankrupt, and they took your product anyway, with the likelihood of you're never getting paid for your product. And so the concept is, it just isn't right. And so we create state laws and bankruptcy laws to deal with this basic injustice of you're selling product in good faith in a situation where you find out later you're unlikely to get paid. And so the theory is, hey, you go back to them and say, yeah, I want my product back. I didn't know you were broke or about to go bankrupt. I want my product back. And that's why it's called reclamation, reclaim. It gives you the right under certain circumstances, or may give you the right to either get your product back, or in the context of a bankruptcy filing, get a special claim, possibly against the estate. So this is the UCC section. I'm not going to go into that in a lot of detail. I'm really going to focus on the bankruptcy section that basically replaces that in the context of a bankruptcy filing. What's interesting here is that you basically get 10 days to make a reclamation demand, and that's a different deadline than you're going to see in the bankruptcy context. This is 546C1. So this is the statute that replaces. I'm going to be going into cases and just summarizing this real fast. And and I'll be going into it again. But basically, the really important thing that you need to remember is that there are a couple of deadlines and timeframes here. You can demand reclamation for goods delivered in the 45-day period prior to a bankruptcy filing. That's the magic number. You delivered goods within 45 days of a bankruptcy filing. Those are the goods that you may be able to assert a reclamation claim for. But there's a deadline. The deadline is also 45 days. You have to give written notice within 45 days. That's 546C1A, not later than 45 days after the date of, from our perspective, delivery of the goods or receipt of the goods by the debtor. But there's a wrinkle there too, because let's say the 45 days hasn't run out. So let's say you deliver product 20 days before the bankruptcy filing, and you have 45 days to file the notice. So on the date of the bankruptcy filing, you still have um, more time to theoretically your 45-day period is not run out. So what happens then? Your 45-day period is extended. However, it's only extended 20 days after the date of the commencement of the case. So in other words, however much time you had left to give this notice, in other words, however many days you had left in your 45-day period, it's not extended to that degree. It's extended 20 days. You could have had less than 20 days. You could have more than 20 days. It doesn't matter. It's extended 20 days. 20 days is the magic number, which is not a lot of time. So 20 days after the bankruptcy filing is the deadline for filing a written, or actually for serving a written notice of reclamation. Not to be too confusing, and I'll go into it later, but there's another code section called 503B. 503B is not the same as the reclamation section, which is 546, but 503B allows or provides for an administrative payment claim, which is a high priority claim, which is much more likely to be paid 100 cents on the dollar than a regular unsecured claim. And when does it, and under what circumstances can you get this claim? If you provided goods to the debtor within 20 days before the date of the commencement of the case. In other words, you ship product to the debtor within 20 days prior to a bankruptcy filing in the ordinary course, then you may have a right to a 503B, regardless of whether you provided written notice pursuant to 546. In other words, it's not a reclamation claim. Whether you have a reclamation claim, whether you don't have a reclamation claim, whether you provided written notice, whether you didn't provide written notice pursuant to 546, doesn't matter. You still have a claim under 503B. So this is a very important section because you have to look and see if you delivered goods. It's extremely important to assert this right, since it makes a difference between getting an unsecured claim on which you're going to get paid bupkis and an administrative claim, in which case you may end up getting 100 cents on the dollar. So there are real dollars involved here, and it's important to assert this right, which, by the way, often is not asserted. It's important to know that the laws change here, maybe dramatically. 2005 46C was amended. Theoretically, it seemed to give reclamation or folks asserting a reclamation right a better claim. It expanded from 10 days to 45 days. It also gave a 20-day period after the bankruptcy filing. However, some courts have interpreted some of the language changes in the statute as meaning that whereas prior to 2005, a reclamation claim was pretty much automatically given administrative claim status, after the 2005 changes to the bankruptcy code, a number of courts decided that the changes in the verbiage in the law meant that the court no longer had to give administrative claim status. And there's a division in the courts on this. So depending on what bankruptcy court you're in and where you're in the country, you may go through a lot of trouble to get a reclamation claim and still get bupkis. In other words, just get an unsecured claim, which I guess is better than nothing, maybe. Instead of getting the golden admin claim, which you still may get in other parts of the country. So the U.S. Supreme Court has not resolved this issue, and a lot of court of appeals have not yet spoken on the issue. So there's confusion, and there's there's going to be a law that's which has important implications is going to be applied differently in different parts of the country, unfortunately. Check with your lawyer, like me, if you end up retaining me in this kind of situation. It's very important. Yeah, this slide just repeats what I just said, which is even if you don't have a reclamation right under 546C, you still may have one, not a reclamation right, but you still may have rights under 503B9. Another important change in the verbiage on 546C, which is bad for reclamation claimants, is that there's another division in the courts. Some courts have decided that the new verbiage means that if the debtor had a new secured lender with rights against all the property of the debtor, which by the way is typically the case, then those new lien rights are going to trump the rights, the reclamation rights in property in the property that's trying to be reclaimed. There's a division in the courts here too. We'll go into some of these cases. If you don't have, if that's knocked out by the new lien of a new lender, then again, you're only going to get an unsecured claim. You may not even get that. So there's a lot of unclarity in the law as to that issue, and that's an extremely important issue as well. Okay, so this is just a sort of a convenient summary of what must be shown in some of the deadlines. I'm going to flip through it. You can always pause if you want. Okay, let's take a look at the first case. So this is a 1998 case before the 2005 changes. However, this is probably still good law. Just for the proposition that a reclamation demand must be in writing. Well, here you have the typical tragic story. Goods are shipped, no payment is made, demand is made, no response. They went over to the debtor's premises and took it back. The problem is they took it back under the state law statute, which apparently we'll go into in a second. Apparently didn't require a written demand. They didn't take it back pursuant to 546, which does require written demand. So something not so good happened. Well, trustee is appointed. The trustee sees that the product was transferred during the 90-day period prior to a bankruptcy case, and the trustee sued them for preference. And, you received goods from the debtor within 90 days, and that's a preference. So the issue there was, well, did a right of reclamation under state law trump the preference action? By the way, if you want to know what a preference is, I have about 1,000 videos on my website. 99% of our work is defending, well, I would say that higher, but a large percentage of our work is defending preference in fraudulent conveyance cases. So I'm not going to go into it here. I've got a ton of videos that you can watch. Suffice it to say that it's a transfer within 90 days prior to the bankruptcy. The benefit of 546 is that it protects you from a preference lawsuit. It's an exception to the preference lawsuits, to the preference law. So that's one of the reasons it exists. Unfortunately, in this case, there wasn't the proper written notice, and so the defendant lost that right. And in the end, the defendant lost the preference case. What's the moral of the story? You have to give written notice. It's not going to be good enough to just assert a state law claim because you're not going to be protected from a later preference lawsuit. Well, what if you didn't give written notice and you get sued for preference? Does the debtor get back the value, the market value of what you sold the product for that you took back during the preference period, or does he get the liquidation value of what you took back during the preference period? This is assuming, for whatever reason, it's not protected under the Bankruptcy Code Reclamation statute. A trustee sues for preference. Well, it's a 2005 case, activewear, and I'm not going to spend too much time on this. Basically, the law generally is that the trustee will be able to get back liquidation value. In other words, the trustee is going to, if in this case, yarn was delivered, yarn was taken back. So how do we value the yarn? Is it market value or is it liquidation value? And the answer is liquidation value. I'm just amazed how much time was spent determining that issue. This was appealed to the Court of Appeals. This doesn't seem to me to be the kind of issue that the courts need to spend that much time on, but they did. And there's your answer: liquidation value. I'm going to skip through it. And there's your conclusion. If you want to spend more time on those slides, you can always rewind it. I just don't consider this an earth-shaking issue. Well, I consider this a more important issue. The courts have split on the issue as an important issue as follows. So let's say do everything right, put in a reclamation claim, can't be sued for preference. You put in a claim under the code section 546, and everything is proper, and there's been proper notice, written notice. And then you find out, oh, okay, well, you got a reclamation claim, but the post-petition lender took a security interest in all the property that belonged to the debtor, including yours. So number one, you can't get your property back because there's another lien on it, i.e., the super priority post-bankruptcy lender put a lien on it, and but you can have an unsecured claim and basically get bookus. And so all the trouble that you went through to get a reclamation claim, of course, is to get either your property back or a higher admin claim. But a lot of courts find that you don't get one. The lien placed by the next lender trumps your lien, trumps your security interest, your right in the property that you delivered to the debtor. But other courts disagree. So some courts say, hey, your reclamation rights survive regardless of a secured creditor's a blanket lien. So there's a split in the circuits. Well, let's see how it breaks out. So in Delaware, it decided in 2016, the Court of Appeals found that even post 2005 amendments, reclamation claim is not destroyed by a new post-petition lender's lien. In the Sixth Circuit, the Court of Appeals held the same. However, it applied pre-2005 amendment law. So who knows what it's going to do now? A lot of courts look at the language in the amendments to the reclamation section of the Bankruptcy Code and decide that because of the amendments, reclamation, those asserting reclamation claims are going to be trumped by a later secured lender. So the Sixth Circuit was based on pre-amendment law. What it's going to be now, who knows? Southern District of New York decided in 2007, based on the pre-amendment law, found that the creditor's reclamation claims are rendered valueless. So you're not going to get an admin claim in the Southern District of New York Bankruptcy Court, but that's not Court of Appeals level. So who knows what the Bankruptcy Court of Appeals is going to do. Well, let's go to some actual cases. So we're going to take a look at a case where there were reclamation claims made, and uh, the motion seeking an administrative status for those claims was denied. However, the creditor was allowed a claim under 503b9. This is Circuit City Stores. Everybody remembers Circuit City. Bankruptcy filed in 2010, and that's the date of this opinion. So the creditor did everything he was supposed to do, sent letters, gave proper written notice pursuant to 546, and the debtor and moved for an admin claim, or actually filed a proof of claim for an admin claim, and the debtors objected to the claim and sought to have it reclassified, and that's what joined the issue. This is the relevant statute, 546, as amended, and 503b9. Courts have made an argument that 503b9 is basically meant to provide any and all rights that you have as a reclamation. So you don't have an admin claim anymore as a reclamation creditor, but here's a consolation prize. You have an admin claim for this. Any goods that you delivered in the ordinary course within 20 days prior to bankruptcy. Well, there was summary judgment motion filed. Basically, what the court said is that, hey, the law changed, the verbiage of the law changed, and because of that, there is no more a requirement that a court give an admin claim just because you file a 546 reclamation claim. I don't have to do it anymore. It's out of the code. That's basically what this particular court opined. What's interesting about this particular opinion is that it seemed to be distinguishing other situations, because what the court is saying, well, here, these creditors, they sat on their hands, they delivered their electronics or whatever they delivered, and then these things were sold. And then they come around and say, well, we're filing reclamation claims and we have a right to we're filing a reclamation claim that somehow attaches to the proceeds of the sale of their goods, which were in the possession of the debtor. And the court's saying, no, you can't do that. I mean, he's sort of creating the possibility that if a reclamation creditor acted very quickly, filed notice immediately, and the goods had not been sold, and the creditor were able to trace those goods and identify them, then the court is basically saying, or not basically, the court ruled, you can get your goods back. So your reclamation claim is going to be valuable because you're going to be able to get your goods back. But you're not going to get an admin claim anyway. In other words, you can't. There's not an admin claim option anymore. You're not going to get a superior claim. You can get your goods back if you can identify them and if you act quickly before they're sold. Otherwise, you're out of luck. But that's it. And in this case, this defendant was completely out of luck because the goods had been sold already, and there's no longer, under the bankruptcy code, according to the court, there's no longer an obligation to give an admin claim. Okay, well, let's take a look at another case. More bad news for creditors seeking reclamation, but on a different rationale or a different reason. So here, maybe you gave proper notice, everything was done properly, but you still get bogus because you're not going to get an admin claim because a post-petition lender has priority over the goods that are now in the possession. Your former goods that you sold to the debtor, and over which the debtor now has possession, and a new lender uh, um, has a blanket lien, which includes these goods. So you're out of luck. So the case is Simon and Schuster. It's a post 2005 amendment case, and interpreting that new law. Well, the sad story here for Simon and Schuster is as follows. They delivered $5 million worth of goods. That's a lot of books. I assume it's books, to a wholesaler, a dealer of books, and provided the proper notice. And so Simon and Schuster sought to get priority status or get their goods back, and the court ruled, hey, we have a new post bankruptcy lender. The lender has a floating lien on everything, and that includes your books. So you're not going to get anything back, and you don't get an admin claim. I'm getting ahead of myself a little bit, but that was the conclusion. That's the applicable law. Again, you could flip through the slides. You can always flip through the slides if you want. So the court pointed to the language of the new 546 section, and basically said, the new lender is golden here. There was an attempt to distinguish, and the court pointed out, well, in that case, the secured lenders had already been paid in full. So they didn't need your book. They didn't need the collateral. In this case, your books. But in this case, they weren't paid in full, and so they have a right to lien the books. There's your conclusion. End of story. Okay, we're going to look at some cases where things are looking up a little bit for reclamation creditors. First, we're going to look at a case, a pre-BAP CPA case, a pre-2005 amendment case in the Sixth Circuit. We're going to look at it because it's the Farmore case, and it is quoted by other cases in the context of post-2005 amendment cases and application of the post-2005 amendments and application of that law. And the rationale, basically the Farmore case is quoted for its rationale, and it was followed even after the change in the law by some courts. Anyway, so this is a 2003 case affirmed in 2008, and this is at the Court of Appeals level. So the Court of Appeals was affirming the bankruptcy court. And the fact pattern is pretty much the same as it always is in reclamation cases. Creditors provided product. They realized the debtor was insolvent, about to go bankrupt. In these fact patterns, they properly gave notice of reclamation pursuant to 546, and also there was a secured creditor that was approved post-petition after the bankruptcy that had a floating lien on everything. In this fact pattern, you also have a secured creditor replacing a pre-petition creditor with a floating lien, which is also a common fact pattern. So you have the post-petition loan replacing the liens, the blanket liens of a pre-petition creditor, and that's also common. So you have a typical scenario. In this situation, bankruptcy court ruled that the reclamation creditors would get admin claims, administrative claims, high priority claims, despite the fact that there was a post-petition lender. Anyway, it was appealed to the district court, then it was appealed to the Court of Appeals, and the question is, could the reclamation creditors still have reclamation claims against property that they delivered pre-petition when there was a post-petition lien on everything, on all after acquired property. Well, like I said before, bankruptcy court held yes, and drum roll, Sixth Circuit agrees with the bankruptcy court and affirms the decision, and the reclamation creditors got admin priority status. Okay, let's take a look at a case after the 2005 amendments, because that's uh, current applicable law, since the law changed after the Sixth Circuit case opinion. Reichhold Holdings is a case that's useful for reclamation creditors, but seems to me to be a fairly narrow holding. It's Bankruptcy, Delaware, 2016. So in this fact pattern, the debtor had a pre-petition loan with a security interest on all the assets. This loan was paid off in full post-petition with a debtor in possession loan, and the DIP had it replaced the pre-petition loan security interest with the DIP security interest. Before the DIP loan was in place, a creditor called Covestro made a 546C claim with proper notice. And the question was, well, does Covestro have an admin claim? Does it have a right to reclaim its goods, or was that extinguished when the DIP loan was finalized? So it's kind of a narrow holding. There was a loan, it was paid off by a new loan. This reclamation notice was filed sort of in between the two happenings, before the second loan was finalized, but after the first loan was made. So that's the issue. That's the statute. And here are the arguments. The trustee cited case law saying that if there's a post-petition security interest, then in the delivered goods, which at some point there was, but after the reclamation notice was made, then reclamation creditor is out of luck. He has nothing. He has a 509 claim, but he doesn't have an administrative claim for the entire reclamation amount rather. And Covestro didn't give up so easily and argued that reclamation rights came before the post-petition lender's rights, and since the pre-petition loan was completely paid and no longer had a lien, then Covestro should have a valid reclamation right that was not extinguished by the post-petition loan. Well, the Delaware court focused on these specific facts, the facts that the pre-petition loan was extinguished. In the Simon & Schuster case, the pre-petition loan was not extinguished, and that's why in that case the reclamation creditor or claim was defeated as far as seeking admin status. But here, pre-petition loan was paid off, and in this circumstance, the court found that these were two separate loans. The second one didn't. The second one arose after the reclamation rights arose, and therefore the reclamation creditor did have rights under 546 and had rights to the goods, rights to reclaim the goods, and therefore had an admin claim. So The judge followed far more, which was a similar fact pattern. And this is good news for reclamation creditors in Delaware. Of course, it's the bankruptcy court level, but still good news. What takes away a little bit of my joy here is that the stars and planets really have to align with these facts, and they're very specific facts. So it's important to keep that in mind, the narrowness of this opinion. The goods were not sold. The pre-petition lien was paid off. The notice was made prior to the DIP, confirmation of the DIP loan and the placement of the DIP liens. So if the stars align just right and you're a reclamation creditor, then this opinion has value. But it's I would think it's going to be easily distinguished in a lot of situations. Okay, so this is another example, and it's post-2005 amendment. And the Fifth Circuit case, bankruptcy court level. Facts were not so good this time for the reclamation creditor here. There was a pre-petition perfected security interest and a blanket security interest in debtor's assets, and the lien covered the goods delivered by the reclamation creditor, and the right of reclamation arose prior to the pre-petition security interest. In this case, there's apparently no post-petition new lender, so you don't have the situation we saw recently in Delaware. So you can guess where I'm going here. It's not good. It's good for the debtor, not good for the secured lender, but not good for the reclamation creditor. But I always root for the underdog. So that's the statute. So defendants, of course, relied on far more, which is also in the Fifth Circuit, and it didn't work. The court noted that since the amendment to 2005, the amendments in 2005 made the reclamation right specifically subject to the rights of a holder of a security interest in such goods, and the court added and confirmed that although the pre-existing liens did not extinguish the reclamation claims, they're still out there, but they're subject to the pre-existing claims. And obviously, at the time of this opinion, these claims still existed on these goods, and this loan was not paid off. What would be interesting to find out is if this debtor obtained DIP financing that took out the pre-petition loan. Could this situation change? Who knows? But the facts being the way they were, the reclamation claim was denied due to the fact that there was a pre-existing loan.